The April meeting of the Trousdale County Hartsville Planning Commission to order. First, we'll look at our approval of the minutes. You have that in your packet. You've also had that for quite a while. Please look over that if you need to. We'll see if there's any corrections or changes. Yes, ma'am.
So there is a correction that needs to be made on those minutes to match the minutes. The second version that Ms. Carmen sent us, that correction states to remove under new business, under the paragraph that says Jim Carmen spoke on behalf. If you'll go to the next to last, third to last sentence, it says Dave Thomas. Dave Thomas made a motion. Please remove send the request and the word the, and then it'll match her second version of corrected minutes that she emailed us.
Okay. If I see that.
Oh, and I apologize, and remove Katie Dillon from the, at the top.
From those present. Okay.
Am I seeing down? I know that was the.
Good. Did you get that?
Yeah.
Anybody have any other corrections or additions or anything? Thank you, Heather. Keep a line there. There's no other, yes, sir.
I'd like to make a motion to approve with the corrections.
Second that motion.
Okay, have a motion by Mr. Thomas to approve the amended minutes and second by Ms. Bay. Any discussion? All in favor, please say aye.
Aye.
Any opposed, please say no. Yes. Okay. Yes, sir. Roll call. We'll get to that. We're actually here now. You're right. I am. I'm not gonna skip anything. We may skip down to adjourn. You never know. I didn't miss it though. Appreciate you calling my stupidity. Nutter, you want to call the roll?
Heather Bay.
Present.
Katie Dillon. Here. Mitch Gregory. Arthur Harper.
Here.
John Kerr.
Here.
Rosalie Martin.
Here.
David Holner.
Here.
David Thomas.
Here.
Cal Welch.
Here. Got one.
There's a. When Ms. Chitwood was secretary, she would have asked him for a reason, if not made him write off. You young ones never had Ms. Chitwood, no English teacher.
Sorry, touch them all. Trying to think
You're
about.
fine, you're fine, but she would get on to us if we were late. She would actually get on to us. Ms. Chitwood was secretary of this commission she was here when I got here 30-something years ago and stayed forever. She was something. She was precise. All right. We actually have everyone here tonight. It's great.
Sorry, Mike.
Don't worry about it. Anybody have any changes? Any members have any changes or anything that we need, additions or anything to the agenda? Okay, if not, we'll move on to the agenda. First item under new business is a rezoning request. Request to rezone from C1, A1 to C1 by property owners of 3.14 acres. This is on Highway 231 North to combine zoning for future business in the 6th Civil District. Are the people here wanting this rezoning, are they here tonight? Okay. We don't have a podium, do we?
The podium is missing.
The podium, I sold the podium.
I could be pretty loud.
That's, come over right here if you don't mind.
He was late, so I could just use him.
Please state your name so the secretary can get your name and then go into your, whatever you want to tell us.
Shaw, S-H-A-W.
Please continue. Whatever y'all are wanting to do.
We actually will, my husband and I will buy the property personally, but we will be leasing it to a business that our grandson and us own. We are a long haul trucking company. And it is for a place for us to park trucks and trailers when they're not in use. and a shop to do maintenance on our equipment.
Anybody have any questions? Any members have any questions for Ms. Shaw? Yes, sir.
How many trucks are you thinking of having there?
Most of the trucks actually come in and out. We have 27. But our drivers, they come in and drop a load, pick up another load, and most of them park at their homes. So at any one time, we probably have actually 5 or 6 on the yard.
I guess I should restate that. As far as trailers go, how many are you planning on keeping on site?
If every trailer, again, they're not always there on site, but we have 50 trailers. Typically, there's about 5 in a shop. And, again, like I said, they come in, they drop. We have the new trailers loaded for them. And they literally leave a load, pick up a load and leave again.
Of those 50 trailers, a lot of those will be left at warehouses being loaded and whatnot, not all on the lot at the same
It would
time.
be, it's not good business for us to have them all on the lot at the same time. It's our preference not to have them there unless they're just waiting for somebody to come and pick them up.
Yes, sir.
Where will y'all be accessing this? Will we be accessing 231 Bass Road?
231,
No, Bass Road's pretty narrow.
right. No, we would access on 231.
Other questions? Sure.
With you turning it, wanting to do both into one C1, what are you wanting to do with the house? Is that just gonna be the
The
office?
house is a separate piece of property.
So, okay, so this is just.
This
the-
is just the 3.14 acres. If you look at the
Okay.
plat, I think the house is on like 1 point something acres itself. And we're actually buying the rest of that the property that we're interested in buying from the people who will be living in that house.
Okay,
I don't know if they're there now or not, but that's their intent.
So currently y'all just own 2? This one right here, the
Yes.
3.14, you're intending to buy.
If they ever decided to move out of that house and it wasn't $500,000, we would like to buy it. Right now, we're only interested in the 3.14 acres of land.
so what we're dealing with tonight is just property 2.
And you currently don't own it, correct?
No, we have it under contract. Pending that we can get it rezoned.
And Ms. Rosalie said the owners of the property signed the rezoning request and gave them permission to speak for the property.
Yeah, I'd also like to speak, I know that you guys are referencing the TN property viewer of the parcel. The TN property viewer had not been updated with the plat. Now, the plat had been created, if you look at the date on the plat, this had been separated back in 2012, but it was never updated on the TN property viewer.
So it's currently zoned both C1 and A1?
Yes.
Is there a line dividing the 3.14?
It is in the middle. If you look, and I know it's a little small, but if you look towards the side of all the different sold area that's notated on the plat, there is a dotted line there indicating that there is 2 different zones on this piece of property.
Is that from when it was, before it was subdivided, that there were 2 different zonings? And so the zoning didn't just follow the division of the property then?
It did not.
Isn't that normally what we do?
Again, 2012.
I was about to say, this may be when, like the houses on 25, they're on the hilltop.
Yeah.
When, the state, when they did that, they came in down there at the 231 area and just declared everything in the 4-way stop, they're commercial. And I would almost bet that this got caught up in that.
Because it's unusual for one deeded property to have multiple zonings on it, correct?
Well,
And
again,
we've been cleaning those up, but
this, preliminary plat that we're gonna be reviewing tonight, remember, had to go through rezoning. It had 4 different zones on that one parcel of land. Now, if you note here, parcel number 2 does have 3.14 acres, so it did meet the definition of A1 for that parcel. Because 3 acres is,
3 acres.
because it had the 3 acres, it was the smallest amount that it could have.
I would think lot 1 was grandfathered in.
Well, C1, that is all
yes.
C1.
Okay,
Mhm.
okay. Okay. Now, how far are these 2 tracks from the building out there where I know there's a trailer out there that sells tacos.
That's the beach one. It's right there,
Okay,
right there in the point.
okay. And then, that's beach properties right there.
Well, 2012 it was, now it is not.
Okay,
Now it belongs to Maria Ochoa.
okay. Oh, yes, ma'am. I'm sorry.
No.
Other questions? Yes, sir.
Just for clarification purposes, then, so we're just considering the rezoning to a C1. What the use is really isn't kind of irrelevant because it can be anything from right. So,
Thank you, ma'am. Ms. Rosalie, do you have something you'd like to say about this rezoning request?
Well, I spoke about how you're not really seeing in the TN property viewer the right line for that. As far as it meeting definition for C1, I think that this would be an excellent case for a rezoning.
Okay. Anybody have any questions for Ms. Rosalie? Ms. Candy?
Good evening, everyone. For those of you who don't know me, I'm Candy Henry. I'm here sitting for Jessica this evening from GNRC. You should have received the staff comments. The staff comments are from Jessica. The things we look at when we're looking at rezoning is what are the surrounding areas, and this property is, it is currently split zoned. The properties to the east and the west are already C1 and some agriculture. Property to the south is C1. Property to the north is R1. So if your task is to look at those, would this commercial zoning fit in with the character of the area? I think the answer to that is probably yes.
Anybody have any questions for Ms. Henry? Okay, discussion. Of course, we all know that our purpose or our job in considering a rezoning request, we have 3 options. We can send this it has to go to the county court. Only the county commission can rezone property. We have 3 options to send it to them by. 1, we can send it with a favorable request from this committee. 2, we can send it with a negative recommendation from this committee. Or 3, we can just send it. Discussion. Yes, sir.
Make a motion to send this forward with favorable.
And a motion by Mr. Welch to send this to the county commission with a favorable recommendation. Do I have a second? Second by Chuck. Any other discussion? No discussion? All in favor, please say aye. Aye. Any opposed, please say no. Will be sent to the county commission with a favorable recommendation. Thank you.
thank you.
Y'all know about when the commission meets and all that? Okay.
Is it okay if we?
Yes.
Thank you.
We didn't want to be rude. We'd be happy for y'all to stay. Y'all ready to leave? I would like. We've got three good taco places. We're a haven for Mexican restaurants.
Thank you.
Thank you.
All right, next on our agenda is preliminary plat approval. And this is for a major subdivision by Maryland Helm of 28.92 acres. This is on Highway 25 West. This includes land down Crenshaw Road, Sulphur College Road, and what they're asking for is 15 lots. Jim, Harold, you represent your son tonight?
Jim, he took a slew of folks to somewhere in Indiana, I think it was, farm up there where they had about 1,000 people gathering to watch. Son get walked out there.
Lives watching.
Yeah, well, we got a bunch of young sometimes. I'm here to represent the Helms. If there's any questions, it's a pretty straightforward division property and some very nice, good, large lots. If my dad had been alive, he'd have bought it before it was for sale. He just bought the thing because he didn't want to take on his house. He's no longer there.
Yeah, that's true. You know this property well, don't you?
Oh, yeah.
Beside where you grew up.
Davis Farm, when I lived there next door to it, when I was 7 years old, just 65 years ago. And then, of course, since passed and Mary Lynn inherited this. It's a good piece of property.
It is. Pretty nice. All right. Anybody have any questions for Mr. Carmen?
Yes, sir.
Mr. Thomas?
So you said 15, there's only 14 numbered. Is the 15,
I was just reading what's on the list, on the paper here, on the
is
agenda.
15 this one here? And the number is just missing off of it?
Or is the 15th on the east
Well,
side of
there's
Crenshaw?
actually two that are missing.
Okay, so the two.
There's a 5-acre tract on this side of Crenshaw and a 5-acre tract right here.
Okay. I didn't know if this was part of, or if they were just leaving this off.
No, it's not that off. That'll be
Okay.
part of the sale of the property.
Okay.
We're missing the east side of Crenshaw.
Yeah.
Just put on this map, but not on that.
There's a 5-acre tract that's on the east side of Crenshaw. That's what actually joined my father's house there.
So Rosalie, does that property need to be numbered also then? So the property says Helm property, that lot doesn't have a number on it? Does it need to be numbered also for the plat?
Mr. Chair, if I may, I can.
Sure, go ahead.
That is a staff recommendation. There is also, we've got the residual, and you might recall this one was before in December 2023. And that previous one did show the two on the east side. And yeah, because it's all still one subdivision, the residual needs a lot number. And then whatever that tract, is gonna be on that east side of Crenshaw needs a lot.
We'd be glad to put a number on the tract.
And as Candy says, that's in the staff recommendations when we get to her report. Anybody have any questions for Mr. Carmen? Thank you, Carol.
Thank you.
Ms. Rosalie, would you like to speak on this?
I do have a question concerning the egress and ingress for lot number 14. Why is that there?
Your question, I'm sorry. It's there to just allow more options for a person to come off the highway if they want to,
Okay,
going down to that 5-acre tract, but now it's not necessary. Not necessary. We just want to make sure that there will give access to it. This will be sold at public auction sometime later in the year. And, you want to make sure that we, I shall say, embellish the tracks with those rights that need to be there.
and as far as soils area, I know,
Yes,
last time-
all of these properties have more than sufficient soil. They'll come up on the final.
As y'all may remember, Jim told us last month that they were in the process of getting the soils done and may lose a track or whatever, but
That was my question for the non-numbered track on here. I thought maybe it didn't perk, and so that's why they weren't adding it to it. I just want clarification.
By the way, Carol, y'all don't have the final soils done yet.
Well, just to be very honest, I'm not that deep into the processes of the office. I keep up with about 1% of what comes off the office, and the other 99% is out of my head. I'm not sure I could even answer.
Questions? No, we'll go, yes, ma'am.
So to clarify, the property that is on the opposite side of Crenshaw, it does have the intentions of being part of this Helm property, parent tract.
It'll be a part of the
So
sale of the
there'll be
property.
seven.
It'll be a different track. It's a 5-acre track. It's, got a tremendous amount of frontage on Crenshaw and also around Highway 25.
That would take it to 17 lots. from-
Yes, that'll be 17, but once again, I don't know how the soil will work out. What we
16.
finally present to y'all will not be more than 17.
I'm counting 16. I count physically 16. but I know there was the 15.
Come in for
Right.
final, they'll have more exact, figures and everything for us. Are we ready to go to Miss Henry? Thank you, Eric. You can sit in if you want to. We'll holler at you if we need you.
All right, I like to sit there, a little bit like to sit there, Johnny Curry.
Actually, I am.
You're older than I am.
2 months.
I'm the youngest one in the class. You're not old, you're old.
We won't get
You children. Well,
All right, thank you, Mr. Chair. So, again, you have these notes in front of you, so I'm gonna hit the highlights, and if there are other questions I can answer, just let me know. In areas that we'll call for your consideration, it's where you have the authority and the discretion to make some changes if you'd like. We do have that State Highway 25 is arterial, and Ms. Rosalie already talked about with lot 14 and 13 and 12 coming in off of that. You can also require a combined access drive for 12, 13, and 14. And it could come in off the easement and just say, we don't want, from that high traffic road, we don't want people breaking and going up what I think is also a steep embankment and that sort of thing. So that is something that's within your discretion. So you can consider making access from Crenshaw. And then reviewing the plat in conjunction with the subdivision regulations, just a couple of details that we're missing. We talked about the residual portion of the property, just kind of confirm it, that's staying with the parent track? What are we looking at lot numbers? What's the total acreage remaining? I think the remnant is a little unclear from, if you look at the math from the previous submission and the current submission. If you just note on the plat, the zoning classification, add a notation, again, regarding that easement for lot 14. The regulations require that the square footage of each lot be provided in addition to the acreage. And this is probably not an issue with water, but where public sewer and water are not available, you add a little disclaimer of the areas to be used for sewage, so they need something there. We need that noted. I think they probably have water 6-inch on part of it, 4-inch on the other part of it. So those are the notes we had, mostly just some requirements that needed some labeling.
And you probably sent that to Gino.
My understanding is that it was, yes.
Anybody have any questions for Ms. Henry? Her report. Okay, discussion. Before us, we have a preliminary plat approval for this 28.92 acres. It involves 3 highways, Highway 25 West, Crenshaw Road, Sulphur College, for 15 lots. Again, this is preliminary, and you'll have more detailed information when it comes back for final. Discussion? Yes, sir.
I'd like to make a motion to approve with the corrections noted in the staff report.
Okay, I have a motion to approve this preliminary plat with the, making the correct changes recommended by Ms. Henry and GNRC. Do I have a second?
I'll second.
Okay, have a second. Any other discussion and or questions? All in favor, please say aye. Any opposed, please say no. It does pass. Thank you, old man.
Thank you, sir. We've grown old together.
Next item under new business is a site plan review. This is for some mini storage units by WH Investments LLC on McMurray Boulevard on 0.91 acres. Is there someone here from WH Investments to speak on this? Please come up, sir. State your name so the secretary can get that.
Stephen Walker,
Okay. Tell us what you'd like to do, sir.
and we're here tonight to present a site plan for sale for a proposed mini storage on Highway 25. Of course, the map and part of there on the description here, 19M, parcel 17.3. Lot adjacent to the dollar store, but it's not Hartsville cabinet, the one next to it. Well, it's between both Jason Ford, two properties, 7 acres, and the lot there on the corner, it's right in those two.
Where the Dollar General store is.
It's over in that area.
Over, okay.
Yes, sir.
And right beside there, if you're looking at the Dollar General, right to the left of there is a 1 acre commercial lot.
That's correct.
And then there's some land there with a sign already on
That's
it.
correct.
So that's the property
Yes,
there
that's
with the sign on it that we've been passing and seeing. And that is 0.91 acres. And they would like to put some mini storage units on it. I'm sorry, sir, I didn't catch your name.
Stephen Walker.
Anybody have any questions for Mr. Walker? No questions for Mr. Walker? All right.
On this, are you having storage units, I'm assuming, opening up both ways? Both
Yes, sir. On, excuse me, this is buildings 1, 2, and 3. On one, there will be 36 10x10s. On the middle unit, there will be 38 10x10s. And on the third unit there, there'll be 18 10x20s. And on that third unit there, the access is going to be straight up. The access will be straight up through here because the drainage retention ponds here and the drainage will come down this side. So access will be here. So the doors will just be on this side, in 10x20s, and these two are all 10x10s.
If they're gonna have, this covers this whole residential lot, right? Correct?
Yes, this buffer zone here,
Buffer zone.
yeah, this is vegetation planted in the back. That's the buffer zone. That L-shaped area in the back, you see it on your
Right.
plats there.
You can see it on it. Other questions for Mr. Walker?
Right here, the only other question I have is this, are you trying to keep this at a 20 foot in between buildings? I know,
Yes, sir. Setbacks for 20 foot off each side, it's the setback lines on the side, the minimum setbacks, and then there's 20 foot in between for access.
okay, because I know before we ran into issues where there was 24 foot in between them, you had to get a variance.
Say that again.
24 foot in between buildings, we had to go in front of the zoning appeals to get a variance.
If it was less than 24.
Yes. Right here, internal driveways, only reason I ran into this.
I know.
A driveway for self-storage facility shall be a minimum width of 24 feet. You know, you can go get a variance, and they should give you a variance, but I don't know if it'd be an issue.
They would have to go to the Board of Zoning Appeals for that variance. We can't do that. And obviously, this is news to Mr. Walker, looks like.
Yeah, I just ran into this. on the way home.
So we need to, obviously, that's, he should go this sale. What's the number of that?
5 each 25 on travel county board.
The will of the body to approve this, we could approve it with them getting the variant, based on them getting the variance from BZA. We've done that before.
Well, I mean, you make a motion or whatever, I don't know what you want to put there.
Because if everything else on the site plan we all agree with,
Yeah.
then we could approve the site plan with that, if he got the variance for
Well,
the.
if everyone else has had to go out to 24, I don't know.
There had to be a variance, I remember.
We all granted the variance? Okay.
It was granted, I'm not saying it was granted, but.
And then do we just postpone it until they get their,
Well,
Do we make approval as long as they approve the variance?
well, I would like to know if that's been something they've been normally doing. You know, I wouldn't want them to take it that we're sending them something expecting them to do that. That's not our job.
and that's.
They should, you know, their policy has been to, go by the guidelines and haven't been often doing the variances. That's, to me, that's a different issue. But you can make a motion for whatever you want. Yes, sir.
I asked a question.
Yes, sir.
And this is, I'm Jared Clayton with Benton Engineering. I was the one that done the site plan. I just want to know, you said it was 24 foot in between them?
In between,
Interesting.
the width, driveway out, self-storage, shall be width, not like feet. On the outside's 20, but when you got doors on both sides.
Okay. 'Cause we didn't run into that on Front Street. I didn't remember catching that on Front Street, but.
I've ran into it before, the only reason I'm.
Is there room for you to do 24 foot between?
Well, that's what I was gonna say. I don't have a scale on me, but I'm not gonna sit here and tell you couldn't.
I'm not saying it's going to go under, as long as the board of appeals is good with it.
Well, if there's plenty of room, I think they
It
should.
says 24, then it needs to be 24.
Right.
Yeah, I'm not, if it's, I'm not, no, there wouldn't be, there would not be room for 24.
Of course, that's a decision they need to make as a business.
Because the two buildings on the outside are, the one on the east side is sitting on an offset line, and the one to the west is probably 3 or 4 foot off of it, so there's not 8 more feet down there. That would have to be a variance.
They'd be asking for a variance for 4 foot. I mean, it's, yeah. But if that's what the ordinance says, then that's what we need to go by.
That's what it says.
I
I know Mitch can.
Yeah. Yeah, I'm sorry,
As I see it, we do have some options.
Yeah.
We can, delay this for a month and let them look at their plat and think about it as a business and see what their business decision is on this, and they can come back. If any member wants to approve it with, pending approval of the, planning of the BZA, you have the opportunity, you have the right to make that motion. I personally don't like putting the BZA under that kind of, pressure myself. But again, you have that option. I'm just looking for a motion. Yes, sir.
I'd like to make a motion to postpone this to our next meeting, giving them opportunity with the new information they've been given to decide what they want to do with the property. That way it's not, we're not denying anything. And
Not at all. I mean, the way I look at it, the gentleman that did the site plan should have
Yeah.
caught this to begin with.
I'll have a talk with Grassley when I get back.
It's on IV 25. Right.
And just for the record, we are in the process of cleaning up our codes and zoning to make it easier to find things. So hopefully in the future, some of this will happen.
Probably what, like I said, happened is on Front Street over here, we had them on one side and the one paid applied and he didn't catch it when he was, and I didn't catch it when I reviewed it. So it's on me ultimately, but
Also, if you have like a point out on your buffer strip, it has chain link fence, on the buffer strip, that the insurance is 7 foot. It's on the privacy fence. For about 10 foot.
It's no pain on the way, is that just, in that where the residential, just
For the
where
residential.
all that.
Chain link fence. Chain link, yeah.
Need a second on David's request.
Of course. I have a motion to, delay this until the, owners have, worked out all of these issues that's been brought up tonight. Obviously, the, verbiage there on the distance between, buildings, and they were, incorrect on their buffer strip and stuff, so they've got some issues to work out. We have a motion to delay this and a second. Any discussion? All in favor, please say aye. Any opposed, please say no. All right, this issue or this item has been delayed and can come back to us at any time that the body is fit. Anybody have anything else to come before the planning commission tonight? That's everything on our business agenda.
Mr. Chairman, I did want to give an update. We did find out from the county attorney that the fee being attached to the blasting permit is going to be done as an ordinance, and that should go before the full public commission this month.
Good.
That is set on the agenda.
I hope they'll, pass that, since there's a, again, that's just to, offset the cost of the administrative cost that the office would entail on dealing with those permits. Anybody else got any zoning news? Of course, we had to stick around. We got a training session to sit through. But anybody that wants to be trained on zoning, feel free to sit in. Anybody that would like to leave, you're free to go.
That's what everybody's been going to, is locking them. Is it, that's been, so I'll. You just. I'll be able to do more.
Thank you.
Thank you. Lots of bringing endorsement of my skills.
Oh, no.
Yeah.
Okay.
Nice.
Yeah. I was thinking, like, what I do right now is I just like right next to it, you know? But yeah, it's not great. I don't do trains.
All right, we're ready to begin our training session. Happy to have some members of the BZA here tonight. I don't never like to just put y'all on the spot. If y'all, that, to me, that would have put y'all on the spot and I don't think we should we need to make our decisions and then y'all need to make y'all's. I don't think we should do that, is put the BZA on the spot like that. And if you ever feel like that you have been put on the spot, just delay whatever you've got in front of you and let's talk about it or something. We appreciate it. Thank you. Thank you. All right.
Okay, I am, thank you, Mr. Chair. I'm starting a 30-minute timer, and when it goes off, I'm gonna stop. So we'll get through what we get through, but I'm not gonna keep you here any longer than I need to this evening. So if you'll look at the top, these are kind of the topics that Jessica has been going through with everyone. So we're handling the things that are in orange tonight: rules of procedure and professional conduct, open meeting laws and public hearings, and conflicts of interest. And so that first part, when we call rules of procedure and professional conduct, we also call that sometimes the rules of parliamentary procedure. And I think it's helpful to know because, jurisdictions vary in the way they do things, and that's allowed by law. So for example, you don't have to have bylaws. That's not a requirement. You don't have to pass bylaws. But there are some requirements you have to meet, and that's why most people end up passing bylaws. It's because it's just kind of easier to have your rules in one place. So for example, a planning commission is required to have a chair and elect that chair to a one-year term. A planning commission has to adopt some rules that go for the transaction of business and keeping records, and then the rules that define any officers that it needs to get its business conducted. BZAs also have rules. They are subject to any rules that the county legislative body wants to put on them. If the county legislative body wants to pass some ordinances and establish those rules. And then the BZA can adopt supplemental rules to any of those. And that would deal with matters such as how they keep their records, their leadership, their officers, and the circumstances under which and how they want to write down their findings of facts and the reasons for why they did what they did. So in general, every organization that's conducting business needs to have thought through, how do we do it? What is our procedure? Many of those businesses land on Robert's Rules of Order. I'm sure you've all heard of. So it's the most widely known source of parliamentary procedure. It's not the only one in the world. There's no requirement that you have to adopt Robert's Rules, but you should make sure you do have some procedures for how you want to do deliberations. So the things that you're thinking about when if you're reviewing what you have or establishing something new, what are your meeting schedule? Do you want to have regular meetings? How often are those regular meetings? How do you want to call special meetings? What are your responsibilities for that? Who sets the location? Who drafts the minutes and circulates them? That sort of thing. For your agenda, how are they established? How are they addressed? How far in advance must somebody get something to you for it to appear on the agenda? Or how far in advance must a staff report or a recommendation get in the packet before it can be considered? And then motions and voting. Who can bring a motion? How do you amend motions? When you got debate going on, how is that handled? So those are all things that your procedural rules should identify. You also want to identify the person whose job it is to know and interpret the rules. So sometimes you call that the parliamentarian. It's often legal counsel for bodies who have legal counsel come and sit with them on a regular basis. I will tell you that's because lawyers are familiar with and comfortable with going over rules. but nothing about being a lawyer means you have any special training. So you can, Robert's rules is an entirely separate thing, so you can have whoever be a parliamentarian, and you're not beholden to a legal counsel for that position. The important takeaway I want you to think about, though, is once you adopt the rules, whatever they are and however you adopt them, you do have to follow them, because there are legal impacts that will happen if you don't follow the rules, even if it's good-hearted, or even if you just are forgetful sometimes. It's that once you establish them, they need to be followed. We'll take a minute to talk about quorum. We're probably all familiar with this. That's the minimum number of members who must be present for you to legally transact your business. Now, the state law doesn't establish a specific quorum number, but the default is going to be the majority of all members entitled to vote. So if you have an ex officio non-voting member, that's not ordinarily going to count towards your quorum. Your bylaws can alter your quorum requirement. Your bylaws can establish different voting requirements for a certain matter. So like if you want to change your bylaws, some people say you have to have a 3/4 vote in order to change your bylaws. Just for there's some consideration to if we're doing bigger things or things that make big changes. So when you're setting your quorum, you want to consider the size of your body and what is the likelihood of your attendance, right? Are there, you don't want to set a quorum that you just are not going to be able to meet on a regular basis because you're going to hamstring yourself. A meeting can happen without a quorum. Once you're gathered, you don't necessarily have to have a quorum to have and conduct the meeting. So if there's information you want to get out and you got people in the room and you've properly noticed your meeting, we'll talk about that in a minute. You can go ahead and have it. What you can't do is transact any business. You don't have enough to make that vote binding. That's a good transition into our Tennessee Open Meetings Act. So it's called the Tennessee Open Meetings Act. It's very often referred to as the Sunshine Law. So it's the same thing. When somebody says the Sunshine Law, they mean the Tennessee Open Meetings
You
Act.
need to give this to the state legislature and Senate because they don't go by these.
They don't have to.
I know.
But when they invite me up to lecture, I'll be glad to do so. The way to think about it is, if you're a public body, you've got some laws you have to follow no matter what procedural rules you're adopting. And so the foundation of that is most of the time going to be the Tennessee Open Meetings Act. And so the law is very clear that in Tennessee, the formation of public policy and the decisions of a public body are public business and can't be conducted in secret. And that's a pretty broad pronouncement. And so it kind of needs to be in the back of your mind. It covers all sorts of things. It covers your notice requirements, the content of your minutes. It covers how you can vote on matters, what's called public voting. Talks about public participation. It makes restrictions on your electronic communications. So I'm going to walk you through some of those. And we'll start with our notice requirements. You have to provide adequate public notice of both regular and special meetings. So probably not going to be okay to decide in January to meet the third Thursday of every month and only publish in January. Even if it's a regular meeting, even if it's established, you want to give notice of that. Now, the statute, at least for now, doesn't really get into what we call the sticky wickets of what adequate public notice is. So we kind of go with what the courts have told us in conjunction with what the law is to make sure that it's adequate. And the notice has to tell the public how they can make comments, that they can show up and make comments and how they do that. And then otherwise, the courts are going to say, if I'm an interested citizen, did I have a reasonable opportunity to know the date you were meeting, the time you were meeting, the place you were meeting, so that I could exercise my right to be present? And where public bodies get into the most trouble with this is those special meetings. Because sometimes it happens and you want to hear something in a particularly timely matter, and that's where the notice can really come around to bite you with the special meetings.
For everybody's information, we've been meeting on the second Monday of the month for the 30 some odd years that I've been on, and we've never had a special meeting. Ever.
Well, and then if you did, you can't get in trouble for it then, right? Can't get in trouble for something you didn't do. Now, some laws have more specific notice requirements, not just what I call the TOMA, Tennessee Open Meeting Acts. So for example, city and county legislative bodies, and this is a pretty new law, have to post their agendas 48 hours in advance. Some charters will have notice requirements for certain matters. And then, for example, enacting or amending your zoning ordinance, that's a 15-day
I would
notice.
assume just putting that up on their website meets that 48 hours.
Well, you would think so. I think that that's the way to handle it because that's the way we both, that we tend
I
to
just
do that.
figured that's the way it was now.
But frankly, if it's my client, I'm also gonna say, put it up in the courthouse, put it up in the post office, it's not gonna, or at least say that this is where the agenda can be located. Now, I'm not your legal counsel, and so that this is just, if I had my druthers, do we still say that? I had my druthers? All right. Okay, so I did talk through a little bit about some methods of posting that notice. So newspaper is a tried and true method for those newspapers that still exist. The thing with that is you got to pay attention to those publication deadlines, just to make sure you've got that in there. Publishing your notice online with websites, Facebook, publishes at places regularly accessed by the public. And that means that, where the public kind of knows they can go to, they have a right to be in. So courthouses, city hall, post office, that sort of thing. But, if Walmart has bulletin board, you can post it there. And, that's where there's public traffic walking back and forth. The way to think about it is there reasonable access by the public, and are you consistently posting there? So that the public can, once they come to know that that's where they can find information, they can rely on that. And then just, remember your charters, your bylaws, other laws may have more specific posting requirements, so you got to follow those too. Talking a little bit about the TOMA requirements for voting, and very few bodies I've noticed have issues with this, but it always is a good refresher. The law is specific about the types, the way we vote. There is what's called a public vote, and that is the all in favor say aye, all opposed say nay. And aye and nay are literally written into the statute there. There's also a public ballot is also allowed. So if you wanted to do a written vote, that would be okay, but it cannot be an anonymous vote. So you could do a written ballot if that's an easier way. You need to come up with a procedure to make sure that somebody's printing the ballots, proofing the ballots, and collecting the ballots and counting the ballots. I think that's why most people don't do written ballots, but it's allowable. And then you can do a roll call vote. And that's a good idea to do when you have ayes and nays, and it might be a little hard to tell where we're landed on things. But some bodies always do a roll call vote just because, so that it's always public. What you got to remember is any sort of secret vote, secret ballot, anonymous, that is not allowed for voting purposes. Now it's funny, we jump in and we talk about a meeting and open meeting requirements, but where we sometimes get tripped up is the basics with, well, what is a meeting? And that's a really important thing to keep in mind as a public official. Because all meetings are public meetings open to the public at all times. And it's talked about in terms of a governing body. And so a governing body is members of any public body consisting of 2 or more members. And then that body has authority to make decisions or recommendations, even if they are only a committee, for example, that can only make recommendations. If they have the authority to make those recommendations to another public body on that policy or administration, then that meeting is a public meeting. And it means if you've got wherever 2 or more are gathered, right? That's a good way to think about it. And there's this other language here, and I'm on page 56 of my slides. The convening of a governing body for which a quorum is required. That does not mean that you have to have a quorum to have a meeting. We already talked about that. If you've got them gathered, you're having a meeting. It's just that if that body is a body that uses a quorum to vote, which they do, right? If you've got more, if you've got more than 2, you do. And there's this language about if you're meeting to deliberate toward a decision, and people can get into the weeds about that. The way to think about it, the way the courts have interpreted it, is that deliberating, it means what it says it means. You're weighing arguments. You're talking through, well, on one side this, well, on the other side that. So you don't have to make a decision to get yourself in trouble with an open meetings violation. Just talking about the issues can be a problem.
I would think the bodies that could have problems with that one, are those that have work sessions.
Right, and now work sessions you need to notice your work sessions, you need to come together and talk about it. and make sure that they're open to the public, even if you're not deliberating, even if there's not an action item. Just treat it as if it were. And that's the way to not get in trouble. But, and we'll talk a little bit more about it later, there are some other things that can get you in trouble just because of human nature. You know, I like to take this point and say, you know, in a post-pandemic world, it's still important to remember that the meetings have to be in person. The COVID emergency regulations are all gone now. You can't use Zoom. You can't send emails back and forth. You got to be in person. Now, there are some limited requirements, and I put a couple of limited exceptions.
It's my understanding, as far as the school board goes, that a member's allowed 2 meetings through a year through Zoom or through on the phone when you can see it.
FaceTime.
FaceTime.
I will say, so that has existed in the past, and then there are some other, there's a limited exception for state bodies, which of course doesn't help us. And there's even a more limited exception where some local bodies can get permission to have an electronic forum. But as a general rule, a local body of government is just not going to be allowed to count that. So now that we've talked about that and what is a meeting, what isn't a meeting, let's dig in a little bit more to what isn't a meeting. Yes, sir.
Before we move past this, the former mayor, being an attorney, interpreted that any meeting could consist of 2 commissioners talking in the parking lot about issues that are before the commission.
No, well, it's funny. I've got a hypothetical later in our talk, but let me go ahead and answer that. And I'm going to give you the lawyer answer, right? Which is it always, the answer is always, it depends. But I will say, I personally fall on the stricter side of that as well. And we have some case law, particularly out of East Tennessee, where the courts there have taken a really strict interpretation. Now, we're here in the Middle District of Tennessee, and our courts have taken a slightly more liberal interpretation of that. But yes, it is absolutely possible, and that's what I was talking about with human nature. When the meeting's over and you're walking out to the parking lot, and you're talking about something you deferred, and when it comes back up, you know, you really want to be wary about that.
So how can a member ever relate to another member information about, I know they can't during the meeting, but I mean, if 2 members of any body, say run into each other at Piggly Wiggly, and did you know such and such is coming up at our next meeting, and obviously everybody knows you can't deliberate to make a decision, but information gathering.
Well, so part of that is an honor system thing. That there is a line that you have to draw, because that factual thing, right? Did you get the email that says this is on the agenda? You're not weighing arguments for and against it. Except that if I said something like, did you say John Doe put that back on the agenda for next month? Am I forecasting something in the way that I'm talking? Am I indicating that I have a position on something? Am I putting forth an argument one way or the other? So you really do, like, the answer to your question is, how can 2 members ever get together and talk about something, is pretty much, you're not supposed to. Now, I will say that doesn't mean you have to ignore each other, because there are some specific exceptions. One, if you have an on-site inspection of something, and some bodies do that, an on-site inspection is not a meeting. You're not supposed to be deliberating, but there's an awareness that to go and inspect something is something different than a meeting. And then a chance meeting is not a meeting. When you run into somebody at Rotary, or if you're in Sunday school, or you know, you're in the grocery store with, it's absolutely okay. You can be friends, you can socialize, you can get together and talk about an email regarding all the things that aren't related to your government business. But when you start talking about government business, that's when your yellow light goes off. And it's true, most of the time people aren't going to be there, and it's an honor system thing. I will just say it is difficult to talk shop without talking shop, right? And it is specifically illegal to rely on that chance meeting to cover up a conversation if you did actually. Like that is talked about. Now, another area where sometimes bodies will get in trouble is what's called, their executive sessions. Y'all familiar with executive sessions? So, so that's when you meet with your lawyer. And it is when you are allowed to talk about pending litigation. But something that's really important to know is public bodies do not have attorney-client privilege in the way that we talk about attorney-client privilege out in the public. The courts have been very clear that they said when the General Assembly passed the Sunshine Law, the intent was to waive attorney-client privilege for that public body. Now, what it can't do is take away the right of the client to get certain information from its lawyer. So that's where that really narrow executive session exception comes into play. And so on slide 60, I've got kind of the 4 big rules for executive session. And rule number 1 is your lawyer has to be there. And I also say your lawyer needs to tell you who, if anyone else, is allowed to be there. Because if you open it up to somebody who doesn't have the legal business to be there, then you're running into a public problem and you're running into a confidentiality problem.
Can you meet with your lawyer on Zoom?
That's
Does
an
that-
interesting question.
Make them be there?
Here's my answer. I think there is probably a way to make a Zoom executive session work. As we know what well, I will say in my experience, most executive sessions are part of a noticed meeting. And the reason is for that is so that you don't leave yourself open to accusations. So I would say there is probably a way to do that, but I would tread very carefully and make sure that the lawyer, and of course the lawyer's gonna be the one being okay with it if they're zooming in. So it has to be talking about pending or threatened litigation. And I don't mean somebody who's like, well, I'm gonna get my lawyer. No, there has to be like a reasonable certainty that, that the threat of litigation is real. And the public body has to be a party, right? It's not just any suit. It's one that the public body might be a party of. You can provide facts and information to your lawyer. Your lawyer can take that information and provide advice about, well, these are the legal ramifications if you do this. And these are the legal ramifications if you do this. And this is how court procedure works. What you can't do is have discussion. And I will say I have been in executive sessions where I've got my people gathered and I've got the information in front of them and we're doing the information exchange, and then somebody wants to turn to their partner on the left and say something and I go, we're not doing that. So your executive session is a really narrow.
Y'all know you're being sued right now. The Tennessee Court of Appeals just hadn't ruled on the shit. Okay, just wanted to let y'all know. Boosh, you weren't here around, but you're still being sued.
Now, which side of the road was it on? I thought it was. I didn't mean to deliberate.
So those are your executive session rules that some of you may become more familiar with, I gather. We'll talk a little bit about your minutes. Robert's Rules provides guidelines for a minutes format, but there are also some legal requirements for your minutes. Those are laid out in the Tennessee Code. Your minutes have to include a record of persons present. They have to include all motions, proposals, and resolutions offered. And they have to have the results of any votes, including a record of individual votes if there is or not. That's what the law says you have to have. Now, there are other things you can include and that are sometimes a good idea to include. Sometimes if a body wants to be very 100% certain that the record shows that there was full consideration of something, you can put in more of a summary of somebody spoke and said this and somebody spoke and said that. And then for those bodies, particularly like the BZAs who might be making fact findings, you come up with a way to record that in your minutes. Your minutes have to be promptly and fully recorded, and they have to be open to public inspection. And so in general, you just want to make sure you've got your system in good place. What's your system for reviewing, for approving, and for certifying those minutes? Who signs off on them? Is it your secretary? Do you have a staff member? How is that done?
Who does sign our minutes? Is anybody?
Everything are submitted and we approve them.
You vote on
We vote on them. and
them. Well, like, we do that on the school board also, but as chairman of the school board, I sign those minutes every month. They're not official till I sign them.
For my board.
And I just wondered who signs them for this body.
Yes, it would be you.
It never has been. To my knowledge, it's not. Huh?
Add a blank.
No, I don't mind. I'm just saying, do we know? I mean, that
I,
might be something that, what's his name needs to tell us. What's our lawyer's name? Yeah, Mr. Beller might need to answer that question.
I
That
haven't
is
seen,
our motion second and vote enough of a signature.
Yeah, I don't know. I'm just saying.
yeah, I haven't seen any signed copies of the minutes since I've been here.
And I think, you know, and it's one of those things, and your own experience shows it, right? It is the typical thing to do, because that is a way to certify that something happened. On the other hand, it is not specifically, you know, what the law requires is that it's recorded. The law doesn't have a specific certification
Like
process.
you saw us earlier, we went over the minutes, any corrections or anything, and then we voted and passed the minutes. You're saying that's sufficient?
I would, again, not your lawyer. I know Brandon, and I know he'll give you the answer that you need. I mean, I would say that is, you're probably meeting the technical requirements. And then the question is it good practice to have somebody sign?
I would say since our minutes were used directly in the current court case, and that was never brought up.
I think that we're good. I think that's what she's saying, that we're probably good,
Yeah.
but,
I've been a secretary once. They didn't ask me back because I write down every single word that's said. So,
no, she said summary. Not every single word.
I took notes on the statement. I did. And I'm grateful yours are not every word for your sake too. So, and those is, I signed off on the minutes after they were approved by the next meeting. And then I've also been the chair where I signed the minutes are approved after that meeting as well. And then that way it's a done deal and you're both safe.
I mean, I'm not saying we have an issue. I just wonder.
I think one of the things is if you just take the minutes, how do you know by looking at them that these are somebody that drafted up or that these have been voted on? You see what I mean? So I think that's probably the question of certification.
This is the approved set.
Right.
Like tonight.
Because otherwise it could just be,
Tonight had a change.
could just be pieces of
Who
paper.
signs the minutes for the county commission?
We do.
I would have to have, Amy would know that, but.
It may be that no county committee
Yeah.
has anybody sign. Again, I was just referencing the school board because the school board's always had the chairman do it. The county may not have ever had it. There may be when they're passed that they're done.
I'm thinking the subcommittee minutes, I don't know of anyone who signs those. I mean, I'm the chairman of one of those and I've never been passed or pointed out.
Again, I'm not saying we have an issue. I'm just saying.
Yeah.
Is it an opportunity for?
Right, exactly.
best practice?
Because to talk about the being submitted to a current court case, the lawyerly objection there would be to authenticity. So nobody objected to the authenticity then.
Right.
Doesn't mean that maybe next time around they might not try to cause a
Chancellor,
problem.
and now it's been to
You know what
the
I mean?
Court of Appeals, so.
Yeah.
Obviously, they were pretty good.
Yeah. Well,
We
we're,
didn't get called on.
That might be something that we do at our next meeting is put that as a motion that we start signing our minutes.
I would,
well,
I don't care. I mean, again, that needs to be a county decision that the mayor, I mean, if the county's gonna do that, they need to do it for every county body.
Yeah.
Not just this body. So, I mean, that's something that the mayor and
I was just
I
saying.
know I've got the dude's name again,
Yeah,
but, you know,
maybe that's something that we need to do just in this body because I can see
I
that.
don't want to be different from the others. Yeah, that's how you get in trouble.
That is how you get in trouble. You're right.
Because when you got this one doing it, why, if I was an opposing lawyer, I'd say,
Yeah, the consistency.
How they're doing it.
right, right. I would use that against you.
Yeah.
we're all.
You-
I'm going to decline to answer that one. I'm going to skip because we've only got a couple of minutes left and I know you can read through this on your own. So I'm going to go to page 64, because these were some of the hypotheticals I came up with for the open meetings. And we've talked a little bit through this, but these are some things that I think are good to talk about. And I think it's also a good time to talk a little bit about email because email is where sometimes we can get in trouble as well. And one of the things we recommend is, don't inadvertently start an email chain of people talking. And the way that sometimes happens is if maybe staff sends an email, sends a packet out, or sends some updated information. We're meeting at the courthouse, not the community center, and then somebody starts replying all, and they start asking questions. And I don't want to speak for Rosalie, but in my experience, staff is more than willing to help and more than willing to answer questions. But it's better to do a single email. You can't get in trouble for the single email. You can't get in trouble for emailing your staff. You can't get in trouble for talking to them. You can't get in trouble for, that's, if it's just you, then you can't be deliberating. And so and then the other thing that we can't do is you can't use the staff as a conduit. So I couldn't say, Rosalie, I think this, will you make sure to tell Jeff when he calls you about that, right? So you gotta be thinking about that. But other things, if a constituent emails you about something, right? You want to make sure that comment becomes available, but you don't necessarily just want to forward that to everybody and say, hey, all, here's what Joe Smith emailed me. Again, I would run that through staff. Because then that can be disseminated, it can be made known to you, but you're not in a situation where you're inadvertently opening the door to kick off a conversation. Because the courts have found sometimes that those emailed conversations became open meeting violations. And the violations are pretty serious.
Can I say something?
Of course.
Just be aware that, and I'm surprised actually that we didn't get a hit on it with this last court case, is that a lawyer can ask for members to not delete or do away with any emails or any electronic, because that's part of the public record, and you can be made to keep those, and they can subpoena those through the open records request and all that stuff. If I email you or something, that's part of our job in this thing. You can't just, oh, it's stupid and delete it. You better not. You get hit on that, right?
And I think that's probably a good place to leave it. Yeah, those records requests can be, and the records laws can be really expansive. And that is something where I would definitely say, make sure that whatever the county policy is on records, and then you gotta pull in your county attorney and say, because if that can vary, it can be that like you don't have to keep routine correspondence. But if you have it, if it's in your sent mail, then it's subject to an open records request, to a subpoena, to an order directing you not to, to have your phone examined for anything else that you may be using. So it is very important to think about all of those records that you are creating and be cognizant that that's about being a public official.
And we've never done that on this body. I would have loved for them to have seen the text messages I got on this rock quarry and all the threats of, and all of that kind of stuff, because some of them dudes needed to be prosecuted. Yeah. But we're not bad. This committee's never been bad about doing things like that, texting each other and emailing each other and that kind of stuff, but there are bodies that probably do that.
Well, I'm going to stop us there. I appreciate the chance to hang out with you guys tonight and talk about it. I hope this is helpful. Again, we're going to make sure these materials are available electronically. And then I'd imagine whenever the next training is, that you'll just pick right back up at 65 and you can file through the rest of it. In the meantime, if you have any questions about me, it'll take me a few minutes to pack up, so I'm happy to answer any. Yeah, we'll make sure those are available. Yeah.
Before we adjourn, it looks like we're going to be, the commission will be meeting at the courthouse for a work session this month. Really? So I would assume. So I would assume next month's meeting would be available as the courthouse if you wanted to do that.
Well, of course. I think.
And that'll help with our video.
Well, I think we should get back home. It's easier to run a meeting there and everything, and I'm just really glad that our rock quarry issues didn't come up while we were having to meet in here. Yeah. It actually could have been a dangerous situation. If you go back and look at those text messages I got, and so, some of y'all probably got, there's a lot of idiots out there. The only one I'd like to meet is one told me that they heard I got a new truck out of that deal. Because I'd like to tell them, I wish I did. I got a 19-year-old truck. I need one.
Adjourn, Mr. Chair.
Have a motion to adjourn. All right. Motion by Mr. Wells. Second.